Okay, well, I think it's about 8:35. So I think we should get started. Okay, so I'm Shawnee Collymore. I'm an estate planning and elder law attorney here at Cody McCarthy. I've been practicing estate planning and elder law for about 14 years or so. And today's presentation is going to be about some strategies and how you can protect your home.
And I'll just introduce myself quickly too. I'm Denise McCarthy, also Cody and McCarthy, and have been practicing for about 14 years. Thank you everybody for taking time out of, I'm sure, busy schedules. Try to squeeze this in before work for some of you or before kicking off your day. So thank you for being here.
Okay. So generally, when people talk about protecting their home, what are you trying to protect it from? Sometimes people, when they come in to see us at the office, they don't really even know, because you can hear a lot of things on the radio and on TV, and it can be confusing as to exactly what you're trying to protect your home from. So primarily, you are trying to protect your home from Medicaid, which here in Massachusetts is run by Mass Health. Secondarily, things that you might be concerned with are avoiding probate, reducing or eliminating estate taxes, protecting your kids in future inheritance from divorces, bankruptcy, creditor issues, all like that are also things that you might be concerned with. But the primary thing when people are coming in, they're thinking about how they can protect assets from nursing home care. And for a lot of people, their home is like really sacred. So Medicaid, like I said, it's run by Mass Health here. It is a federal program, but all the states run their own Medicaid program. So every state will have a slightly different name for their program. It's not the same as Medicare. People find that very confusing, Medicare, Medicaid, because the names are very similar. But Medicare is what you guys pay into, what we all pay into every month. You pay into Medicare, and it's something that you've paid for. Medicaid is a public benefit program that you have to be eligible for with financial need. So generally, people apply for Mass Health for financial assistance, paying for long-term care, nursing home care services. And that is just because the average cost of nursing home right now is like $15,000 or more every month. So the average person, if you don't have long-term care insurance or large savings, can have trouble paying for that level of care for a long time without impoverishing the spouse that's not sick. It's just a huge burden. So people come to us to try and strategize about how they can protect assets from this expense, and maybe position their assets in such a way that it might be easier to qualify for Medicaid. And a main asset, like I said, that people are really concerned with protecting is their home, because there's this like a feeling of like, well, at least if all else fails, my kids have the house. Which is really sentimental for people.
And one thing I'll add, and I know you're going to go into the eligibility requirements, but I just want to emphasize this because I think people really don't know this coming into the process, is that they're looking at the couple's assets.
Yeah.
I think a lot of times people are thinking that, okay, well, if I'm married, it's only me that needs the care or needs to go to the nursing home. One of us has this horrible diagnosis. If they're just going to look at my assets, but that's not true. They really want to impoverish both spouses. They'll let the spouse that doesn't need care keep a little more, but they are looking holistically. So when we do our planning, we're also looking across the board at all of your assets.
Yep, that's true. And to be eligible for Mass Health Medicaid benefits, the person that is going to need the nursing home care can only have $2,000 to their name and a primary residence. The spouse that's at home and healthy can have the community spouse, we call that, they can have currently up to $148,620 plus the same primary residence. So it's not that much money. There's some, you know, exceptions to certain things depending on the, you know, but that's going to be your regular benefits is about total 150 plus the house. So it's not that much. So you really do kind of have to strategize. So as you can see, it really is like need-based program and the couple together. And then the community benefits. So there's some programs like PAYS, for Elder Waiver that allow you to get some type of in-home care. And for that program, there is an income limit of $2,742 a month. That if you have more income than that, then you don't qualify for certain like community at-home care benefits without paying this like kind of complicated deductible. That doesn't apply to nursing home Medicaid. That's only for certain in-home care programs. There's no income limit to regular nursing home Medicaid. Okay, so the applicant, like I said, they can have the $2,000. They also are allowed to keep $72.80 in this, what they call like a personal needs allowance. So it's not very much money, but that's like, I guess, think of it like if you need a haircut and shampoo and whatever, like sort of personal things that you might need for yourself, they've allotted this $72.80. After that, there is no income rules for the applicant, but the applicant's income is calculated into what's called a PPA, which is like a patient paid amount. And you can kind of think of it more like a deductible, like when you go to your doctor, you pay your copay, it's like that. So if you do get on Mass Health and you're in a nursing home every month, the community spouse pays from the applicant's income, this PPA amount to the nursing home. And it's basically their income minus this personal needs allowance, minus like whatever their health insurance costs are. So if you have like a MedX plan or whatever, those get deducted. And then whatever's left is what you would pay each month to the nursing home. There are certain exceptions where the community spouse can keep some of the applicant's spouse's income, but I'm not going to get into that. But just generally know that there is still a like what we call kind of like a deductible that you would have to pay each month to the nursing home. But besides that, the community spouse can have as much income as they want. It's just that the applicant's income goes to the nursing home. Some assets that are countable towards this $148,000 that the community spouse can keep: your bank accounts, stocks, investments, CDs, if you have a vacation property, an IRA or 401k is going to count against you. The only exception to the IRA 401k rule counting is if it's like a 401k of a present employer. So if you're happen to be like still working, if the community spouse is still working and their retirement account is of their present employer, then that's exempt. That doesn't happen that often because most people going into a nursing home, unfortunately, usually they're just retired. So, but if you're a little bit younger, you could get the retirement account to be non-countable if you were still working. Some other assets that are non-countable are your primary residence. That's always going to be non-countable. And any assets that you transfer to a Medicaid asset protection trust, that would be something that somebody like us would draft for you in advance, and you could move assets like your house to that trust. Any household items, usually your car, any business assets necessary for self-support, prepaid funeral contracts are not countable, $1,500 in burial, and some life insurance won't count and some does.
Shawnee, just to clarify, so the primary residence is not a countable asset, but are there circumstances where the Mass Health can put a lien against the house if, say, you're in a nursing home and you're receiving Medicaid benefits?
Yeah, so it's always really important to speak with an elder law attorney that specializes in this if you're ever going to apply for Mass Health, because there's a lot of like nuances to it. So the primary residence is non-countable, but if you were, for example, say you did own your own home and you were on Medicaid, Mass Health can place a lifetime lien on your house while you're alive. And what that does is, like, if you sell your house while you're alive, and still in the nursing home, this lifetime lien would have to get paid before you could sell the house. So that way they're kind of like getting reimbursed for what they paid for the nursing home while you're alive. Now, if you never sell the house while you're alive, the lifetime lien exterminates. It terminates when you die. So it's only during life. But then when you die, if you if the house wasn't automatically owned by another person, wasn't in a trust, something like that, it's just in your name, you die, your kids have to probate your estate to gain access to the house. And they can also pursue what's called estate recovery against your house, which is a different process. But Mass Health can just get reimbursed by your estate for whatever they paid while you were alive to the nursing home. And so that estate recovery process is essentially what all of this planning that we recommend and we do is to kind of avoid that whole estate recovery process.
Yeah, I just don't want to give people the impression, because when you see on this slide that it says principal residence not countable asset, I don't want you to then think, oh, well, it's protected just by virtue of it being principal residence, because that's really not true. It means they're not counting it for eligibility purposes, meaning they'll let you get Medicaid benefits even if you have a principal residence that is pushing you over their limit. But meanwhile, behind the scenes, they could potentially, they're during your lifetime putting a lien against it, and they actually kind of force you to keep it in your name so that if you don't sell it while you're alive, and then it's caught up in probate. So they kind of force it into the probate process so that they can then recover after you've passed away. So that's why this is pretty much the reason we're doing this whole presentation, is because it's like the number one asset people that are concerned about Medicaid are trying to protect is the house.
Yep. So so that's true. They do force you to kind of have it in your name if you haven't given it away in some kind of Medicaid trust or whatever.
Yeah, if you haven't done your planning ahead of time.
Trust. Yeah, you can't have it in a revocable trust and be on Medicaid, because that would avoid probate and that would avoid the whole estate recovery. So they don't allow that. So there's a lot of rules regarding that. So you want to, even though, you are allowed to have a house and get on Mass Health, you then have to think of the flip side, which is like how you can avoid this estate recovery process, which is why it's always important to talk to somebody that practices in this area, whether it's us or another firm, just to make sure that you don't, make a mistake. Okay. So some of the ways that you can protect your home from this estate recovery process, and we're going to go into all of these methods in more detail, but the first method is just doing an outright deed to your children or grandchildren or whoever, and just essentially giving your house away. The second method would be doing a deed as joint tenants with rights of survivorship. Third method would be doing a life estate deed, and the fourth method would be transferring your property to the Medicaid Asset Protection Trust. Okay. So the first method, which is just to give your house away to your child or grandchild, essentially you're just doing a deed, and like mom is giving her house to her son outright. That's it. So some pros of this method is that it's like really simple, it's easy to understand, there's no complications. Because mom gave her house to her son, it's not going to be includable in her estate, so you've protected it from estate taxes. There's going to be no probate, but there's some downsides too. So the downsides of just outright giving your house to your child would be that there's a 5-year disqualification period for Medicaid. So this is going to apply to any time you make a gift of your house, of any asset, to another person that's not your spouse. Okay. For Medicaid purposes, there's this 5-year disqualification period that starts until you'd be eligible again to apply for Mass Health. Okay, so the next downside would be that you would have no control of your home if you just gave it away, because you're no longer an owner. If the house is sold, your child or grandchild, whoever you gave it to, is going to get all the sale proceeds because they're the owner. Also, there's no capital gain protection, meaning like if you give your house to your child and it's not their primary residence, they're not going to be eligible for the 121 exclusion, which is essentially that everybody can get this for their primary residence, where the first 250,000 is excluded of capital gain. You only get that on your primary residence. So if your child didn't live there, they're not going to get that. Also, when you give an asset to a person, you give them whatever your sort of like basis, what in the property is, which is like essentially what you paid for it to calculate your capital gains. If you die and like you inherit and somebody inherits their property, the basis in the property always gets a step up to date of death value, whatever the fair market value on date of death. So that's just a little bit better, because then if you sell your house right away after somebody passes away, you're not really going to have any capital gain. So it's just better because you'll have less taxes that way. When you gift your property, you kind of lose that step up. So
yeah, and that if you've owned your home, like some of our clients come to us and they've had the same house for 40, 50, 60
Yeah.
years, it can be a huge difference.
Yeah, it's like 20 grand they bought the house for.
Yeah, it's kind of like we call this kind of like poor man's estate plan. We just give it away with not thinking, okay, you solved one problem, and now you just really cost the kids a ton of money in capital gains tax down the road. This is why we strongly encourage you to meet with an attorney, because that's when we say strategize, that's what we're doing, is we're looking at what are the assets, what's the basis, what improvements have you made, what options do we have, so we can look at all, try to pick as many pros as possible and knock out as many cons.
Yeah, right. And all these methods, like every plan is personalized. So you got to just kind of meet with somebody and figure out what works for you, because it's going to be different for everybody situation. Okay. So then the next thing is, like, when you give your property to somebody, it's not protected from your child's creditors, because it's just in their name. They just own it like all of their other assets. So, they're getting divorced. They have some whatever. They're bad with money. They've got a lot of debt. These kinds of things. The house
applications I would like to mention.
Yeah. Oh yeah.
If your kids are applying for.
Yeah, all of that counts. So that can be a downside. The child also, if people think this doesn't happen, but it does. The child could sell the property out from underneath mom and get kicked out of the house, and there's nothing that mom can do because they gave the house away. And this does happen. People have terrible kids sometimes, or you have a falling out with a kid, something happens, they marry some schmuck, and the schmuck kind of convince them to do these terrible things. So all of these things you're kind of not protected from. So it can be a little bit risky. Option 1. Okay. Option 2 is joint ownership. So this would be like Mary and her son own the property jointly with rights of survivorship. So when two people own a home together, they each own 50% of the house, and Mary dies, son now owns 100%. Automatically, when one of the joint owners die, the other person just automatically inherits their interest without anything needing to be done. That's joint ownership with rights of survivorship. So with this method, each person owns their proportionate share, so 50%. So mom and son would each own 50%, and that does not change over time unless new owners were added or something. So some of the pros of this, it can protect against capital gains a little bit, because at least when mom passes away, her half of the property would get would be includable in her estate. She'd get a step up for her half. And it's also still easy to understand. And, nobody can take her 50% away unless she, gave it away herself. Or so it's a little bit more protection than the first option. But still, some of the downsides are that there's a 5-year disqualification period. And I see somebody has a question, and I think maybe we'll just go over all the questions at the end. So don't worry, we'll get to you. There's a 5-year disqualification period for Medicaid, just like with the other options. So when mom transfers the 50% to the son, that starts the 5-year disqualification period. And if mom and son sell the property, mom is only entitled to 50% of the sale proceeds instead of 100%, because now the son owns the other half. And only the portion that mom owns is going to avoid the capital gains. Well, and also, of course, that depends on how much the capital gains are, but yeah, her half is going to get the 121 exclusion, assuming the son doesn't live there. And then if mom is in a nursing home and the property is sold while she's on Medicaid, her portion of the sale proceeds will count against her for Medicaid. So if she's already in the nursing home, it would have to get paid to the nursing home, or something would happen. You'd have to do some sort of planning. It's not protected from anyone's creditors, and it would get a partial step up in basis, so some protection from estate tax inclusion. So it's a little bit better than option 1. Option 3 is the life estate. So a life estate is basically when you sort of split the interest, the ownership of a property from the person that has the right to live there during life, and then the future owners. The future owners are called remaindermen. So you can reserve a life estate for yourself in a property, and that would give you the right to live in the property for your entire life and get the rents from the property. And then when you passed away, the remainderman automatically owns 100% of the property. And this is all done in a deed. So life estates are valued kind of like in a funky way. So the value of your life estate is going to depend on your age. So the older you are, the smaller your life estate value is going to be. So like if you're a child, your ownership, you're going to have a long life expectancy. So your interest in the property is going to be pretty high, as opposed to the gentleman on the right, who's going to have a much shorter life expectancy, and his life estate interest will be much smaller. So you essentially have to use these IRS tables to calculate whatever your percentage interest is based on your age. And so say if you're 90 years old, your interest might be worth 10%. I would have to run the calculations. If the property was sold, that's what you would be entitled to, that 10%, whatever the IRS tables say your interest is worth. And then that's what Medicaid could potentially get. So as soon as you pass away, the idea behind the life estate is that your interest is down to 0. So now when you die, you have no interest. And so the remainder owner gets everything, and Medicaid gets nothing, because the life estate eventually distinguishes at death, and there's nothing left for Medicaid to attach, because you automatically just don't own anything when you pass away. So it's kind of a interesting technique in that it protects the person from being sort of like kicked out of their home. Like if you just gave your property away, so you always have the right to get into all the rents from the property and live there, but your kid gets the remainder interest when you pass away. But like with some of the other options, if the property was sold during life, you do get a lesser value of the sale proceeds. It depends on your age, how much that is. So the life estate can sometimes protect from divorce and creditor issues, in the sense that the life estate tenant can't be kicked out during their life. Their interest is generally going to be protected. And it is protected from capital gains after death, because a life estate interest makes the property fully includable in somebody's estate. So you'd get a step up in the basis that we talked about earlier, avoiding capital gains potentially for the remainderman, assuming they sold it soon after death. they likely wouldn't have to pay any capital gain, so that's good. And because the life estate happens automatically, like the person passes away and the remaindermen automatically now own all of the house, it avoids probate. There's no need to file anything for the remainder owners to get ownership of the property. It's also sort of more easy to understand. This is not too complicated. It feels the same for mom. Like they don't feel like they've given anything up really, and they can't be forced out of their home. So it's better than the first option where you have no protection. With the life estate, the parent does have more protection. Downsides of this option are also, again, that there's the 5-year disqualification period. If you were buying a life estate interest in somebody else's home, you would have to live there for a year for it to be considered your primary residence for Medicaid purposes. And like I mentioned before, you only get part of the sale proceeds, so whatever the value of your life estate interest was according to the IRS tables. And like I said, that's all based on your age. And there's like these interest rates that the IRS publishes every month that you kind of use to calculate this. And your value goes down, like I said, every year that you age, because in theory, it's like a sliding scale, and your life expectancy is getting less every single year, and so is the value of your life estate. Just like with the other options, if you went to a nursing home and the family decided you had to sell the property, they couldn't maintain it, Medicaid would be entitled to your portion of the sale proceeds, but that's going to be much less than with the other options. You just have to look up whatever the percentage is on the life estate tables and see, but it'd be less than what the other options are. Also, one other downside is that you can't do anything without the remainderman's participation. So like the life estate, the life tenant and the remainderman all would have to sell the property together or mortgage it together. Anything that would need to be done has to kind of be done together. So the life tenant can't really go off and just decide to sell it without the remainderman's permission.
And one thing I was going to add too, because of that case we had recently, Shawnee, where once you've picked your remainderman, oftentimes these life estate deeds don't let you change it. You can actually do life estate deeds where you can reserve the right to change the remainder beneficiaries, but a lot of times they weren't, they're coming to us, they weren't done that way, or they just weren't done that way for whatever reason.
Yeah.
Client was, 1,000% sure the kids, there'd never be a falling out, or everybody would always get along. And it happens a lot where it's like, oh boy, these remaindermen are not really the people I want to have automatically own my real estate. Or, I just recently did a plan where 2 kids really get along and 1 doesn't. So the parents really wanted to leave the real estate in the estate to the 2 kids that get along, just to avoid conflict and kind of give more cash to the other 3rd child. You wouldn't have that flexibility in the context of your full estate plan to make changes to a life estate deed. So I find it kind of restrictive in that sense. But sometimes it is the right option. So I think this is great. What Shawnee's walking you through is kind of all of the options we're playing around with in the back of our minds when we help you come up with your particular strategy.
Yeah, it's important to keep in mind if you want to reserve the right to be able to change who the remaindermen are in the future, you would have to discuss doing reserving a power of appointment in the deed that would allow you to be able to change the owners. Otherwise, you're basically what you've done is a permanent thing, and you can't change it. So that's something you might want to ponder if you think you would want that flexibility in the future. Okay, so that's the life estate deed option. And then the 4th option is the irrevocable trust. So that's the Medicaid Asset Protection Trust that you would draft with somebody like us or another attorney. So it's really important when you're considering doing an asset protection trust that you meet with somebody that specializes in this, because there's a lot, can be very technical in that the process with Medicaid is always sort of like a tug of war, where it's like they're coming up with rules of like what your trust can do and certain things that you can do. And then we as attorneys, we take these rules and we come up with strategies of how we can sort of work around them to still protect the assets while keeping in the guidelines of these rules. And so then that sort of annoys Medicaid. And so then they come up with new rules to kind of get around our new strategies. And so it's like this back and forth all the time. So you have to really work with somebody that like works with Medicaid all the time, or you might not be getting the best product. That's really, really important. Okay. So like I said, it has to be the right kind of trust. It has to be irrevocable. And essentially, the central idea is if there's any circumstances in the trust where money can get paid to you, the donor of the trust, then it doesn't work. That money, at least that portion of the money, is going to be countable. So that's why it's important to speak with an expert.
And one thing I'll just add, because I know people start to see the word irrevocable trusts, and Medicaid asset protection trusts are in fact irrevocable, but for what powers you reserve as the creator of them. So surprisingly, with Medicaid trusts, you can reserve a lot of power for yourself. And the two big ones that in my mind almost make it not even an irrevocable trust, you can reserve the right to change the trustee, and you can reserve the right to change the beneficiary. So if you can reserve the right to change the trustee, that's whoever you put in charge of managing the trust. So you could pull that person off and say, you know, I want a different person. And then because you can change the beneficiary, that again reserves a lot of power for you, because if something goes wrong with one of the kids, like the scenario I was talking about earlier, where, okay, do we want to reconfigure our estate plan, or something's off, we don't leave anything to this kid, whatever it is, you can do all of that with the Medicaid trust because it will reserve that power.
Yeah. And just to keep in mind, when you're doing the Medicaid Asset Protection Trust, the donor, our trust maker, the person making the trust, that's going to be you. And then the trustees of the trust, so you're the person putting the house or money or whatever into the trust. And then the trustee is not you. The trustee is the person that's going to manage the assets inside the trust, that actually has the power to like pay bills, take money out of the trust. You, the trust maker, are just the person basically creating the trust and putting your money or whatever house inside it. And then there's going to be beneficiaries of the trust. The beneficiaries are generally going to be your children or grandchildren, typically. And sometimes we also allow the person creating the trust to have an income interest in the trust, where the person would be entitled to just any income earned on the money inside the trust if you had money. But the bulk of the assets, the principal, is going to go all to your children or grandchildren. So those are kind of like the three important people in a trust, is the trust maker, the trustee, and the beneficiary. So it's important to know that you, as the creator of the trust, are not going to be the trustee. It has to be somebody else. And most of the property is not for your benefit. It's for your kids' benefit. So you're doing this to kind of protect assets for your kids in the future. So it's important to just remember that you are giving something up, but in return, you're gaining the protection of knowing that your assets aren't going to be taken away if you go to a nursing home, and they'll kind of like be there for the kids, which is why the house is a good asset to kind of put into this trust, because you can still live there in the property and not have to worry about it going through this estate recovery process that we talked about earlier, and all those kinds of things. Okay. Some of the ups of the Medicaid Asset Protection Trust is that it could protect against divorce and creditor claims of your kids if drafted appropriately. So if those were concerns that you had, like sometimes you just, you're worried about who your kid might marry, those kinds of things, and you want to make sure that the family assets are protected, you could draft that into the trust to make sure that they have that additional divorce and asset protection. So that's an upside. It could also protect against estate taxes. Typically, it depends on how the trust is drafted, but yeah, you can kind of draft it to help protect against estate taxes. And because the trusts that we typically draft are grantor trusts, you would still be able to get the 121 exclusion if you did own a house and sell it. So that's also important to keep in mind if it's still going to be the primary residence of the trust maker. So that's also really important. And it avoids probate because the deed is in the trust. You don't have to worry about filing the will and going through that whole process when somebody passes away to gain ownership of it. And because it avoids probate, that's one of the main reasons that it's protected from the estate recovery process. And then some of the downsides, like all of the options, whenever you give away property not to your spouse, spouses can always transfer property from one to the other without a disqualification, but for any other person, there's a 5-year disqualification. So when you are doing this trust, you want to make sure that you're trying to do it in advance of being sick and thinking that you're going to need Medicaid eligibility. You do give up control of your home because you can't just go off and kind of like do whatever you want, because now it's in the trust and there's a trustee, a trust that owns it, and there's the trustee that's managing things. So you know, if you wanted to get a home equity line, those kinds of things are going to be very difficult. Not to say impossible, but they're going to be much more difficult than when it was in your name. Like I said, you're not the owner of the property, and you're not the trustee, and you're also not the principal beneficiary. But where it's a home, you really don't feel any different because you're still living there. You can still be paying for the real estate taxes, those kinds of things. So generally it won't feel different, I find, with the house inside the trust. And then with financial assets, like where if you want to put cash in there, you can totally do that as well. Generally, what we advise is not to put cash in there that you're going to need back. So think about like how much money you need, and then put excess money into the trust, because you don't want to be in the position where you have to, you know, you're going to be like dipping in to get money back to kind of just live. That's never a good thing. So you have to really think about what's a good balance as far as funding the trust.
And you can always add over time. So I have,
Yeah.
you know, one client right now is kind of hemming and hawing about how much of her an investment account she actually wants to put in. So she's going to put some in now, give it some time, see how retirement goes, markets improve, hopefully. And she may put more in later. And you don't restart your 5-year disqualification period on what you already put in. You would start a new one as to the new transfer.
Yeah.
So that's kind of nice.
Yeah.
It doesn't jeopardize everything in the trust already.
Yeah, that's right. Okay, so in summary, and there's a lot of options, but after 5 years, if the property is not sold during your life, all of the options that we discussed, the outright deed, the joint deed, the life estate deed, the Medicaid Asset Protection Trust, they'll all protect your home from Medicaid. Some options will offer other protections like reduction in capital gains, estate taxes, or protection for your kids, creditors and divorce option things. You can also combine some of the strategies to get the best sort of strategy for you. And one top thing that we just want to make sure that everybody remembers is to speak with an elder law attorney that works with Medicaid and these types of trusts on a regular basis before you do something like this, to make sure that you're getting the best product.
Yeah, and I mean, a plug for our own firm. One thing I'll say too is like you may find a lot of there's a lot of elder law attorneys out there that don't touch estate tax planning at all. So some of the capital gains tax and estate tax savings that we were talking about, you could, if you're really doing a great estate plan, you may be layering in both Medicaid planning and that type of planning. So I think it is important to look for a firm that does everything, full estate planning, estate settlement. So that means they've settled estates, they're seeing it on the flip side. So to me, that I think that's really important, not just elder law, but that they have like the full breadth of estate planning.
Yeah, I agree.
Do we want to touch on the questions before we go to the next
Yeah,
slide?
yep.
Hi, Peter. Thank you for being here this morning and submitting questions. I'll let Shawnee, why don't you answer the first one and I can take the second one.
Okay. Can a Medicaid lien, can Medicaid place a lien on the home if the healthy spouse is a joint owner? They can do that. Typically, they're not going to be you can't force the spouse out of the home while they're alive. But they could still put a lifetime lien on the property. Typical strategy when we have a married couple and most couples own their home tenants by the entirety, which is a type of ownership reserved exclusively for married couples. So it's like a step above joint ownership. We would advise the applicant to move their half of the house into the community spouse's name so that the community spouse owns 100% of the house, and that avoids the ability of Medicaid to put a lifetime lien on the property because the applicant is not an owner, and that doesn't start a 5-year clock because you can make transfers to your spouse anytime. So that's a standard thing that we would do. We always strive to get the house out of the applicant's name, so to avoid that.
And then the spouse, because you've taken advantage of the fact that you can move assets to a spouse with no penalty, a 5-year look back period or anything like that. Yep. Now that the spouse has the house in their name, we will then sometimes have them put it in a Medicaid trust and get the 5 years going as to them, so that now they could rest assured that no matter what happens to either of them, they're
we do. Yeah, but we would do that after like the person got approved.
Right.
Medicaid. Then after the fact, the spouse that was healthy could put it in a trust.
Good. And then the second question was, if elderly client places a rental property in an irrevocable trust and tenant gets hurt and there is a lawsuit, who is at risk for liability issues? The trustee, the beneficiary, the client? That's actually really an interesting question because I've not ever had that happen. They would certainly, and kind of the way these lawsuits work generally is they kind of throw everything in the kitchen sink at you. So my guess is probably everybody gets named in the lawsuit, but technically the title owner of the property is who should be getting sued, which would be the trust itself. Certainly the trustees, so if it's your kids, they're not going to experience personal liability on that front because they're serving as the manager of the trust. They're serving as a fiduciary, so that it's not them personally. They're just managing this entity. So the kids or the trustees are not impacted. The trust itself could be, say there's a judgment against the owner of the property, that could go, but that would be, I would say, kind of depending on the terms and the way that the trust is set up, that may be kind of moot, because say it's a trust that then goes on to really protect the assets for the beneficiaries. Say divorce protection or something like that was really important to the people that set it up. It could be protected entirely. There might still be some liability for the owner that transferred it. I don't know. Do you have anything to add to that, Shawnee? Because I've never seen that play out, but
I think the trust itself as the owner is going to be liable, but not the trustees individually. I think what your best bet is when you make the transfer of the property to the trust, to make sure that you have updated your homeowner's insurance policy to add your trust as an insured on your policy. That's really, really important to make sure that you continue to get coverage and to have a really good policy, and to have umbrella coverage in case it goes over your regular home limits. If it's a rental property, making sure you have proper coverage for the rental property and liability coverage. That's going to be your best bet of defense, I think, is having proper insurance. So making sure you're talking to your agent and letting them know it's in an irrevocable trust, and kind of getting all the best insurance you can. I think this is your best sort of probably protection.
Yeah, and I would say, kind of just big picture, you're definitely in a better position than you were having the property directly in your name.
Yeah, for sure.
Because you've given away something for sure. It's just a question of how liability would be assessed. According to what you've retained.
Okay, we have a couple more questions. Can the trustee also be one of the beneficiaries? Yes, they could. It's very common to have a child or two children serving as co-trustees of the trust. Just think, depending on what type of level of asset protection you want for your beneficiaries, you may or may not want them to be the trustee alone. You might want, so it just depends on the level of protection, asset protection and divorce protection you want as a factor of who's going to be your trustee. But that's something you can talk about with your attorney. But yes, they could be.
And the other question is about what can you put other assets besides real estate in? And absolutely. So it's just a question of typically what I tell people, and a lot of times people ask us what age they should do it at. I can basically tell them it's not really an age so much as when you can take a look at your balance sheet and say, okay, this I need to have my hands on for retirement. This I'm feeling more like I could part ways with. That could be the ownership of the house because it's not really impacting your day-to-day cash flow. I think that's why most people select it, because it doesn't impact their retirement plan. But then if there are investments or cash that you've saved and you feel like, you know what, I really want this to go to the kids or my beneficiaries, and really I'm squirreling it away for them at this point anyway, that can all go into that type of trust. That's kind of how we have that discussion.
Yeah. And the age, there's not like a typical age, but I definitely think that, once you're in your 60s, when you're meeting with your estate planner, you should be thinking about long-term care and like maybe you may or may not be ready to do this type of trust, but definitely once you're in your 60s, you should be thinking about long-term care and all those sort of elder issues that come up, whether it's just making sure you have a proper power of attorney or healthcare proxy or whatever, but it's something that should be on your mind and you should discuss with your attorney.
And someone asked about the trustee being U.S. citizen. You can have a trust in the U.S. that has a non-U.S. citizen service trustee, but it will be subject to foreign taxation. So because it's treated as a foreign entity here in the U.S. and the taxation of it's so horrible that we really recommend people don't, because there can be things like the recognition of capital gain with transactions with the trust that we don't get if it's a non-foreign trust. So generally, we strongly advise people not to select a non-U.S. citizen as a trustee of a trust. And that goes kind of across the board in estate planning, not just these irrevocable trusts.
Yeah.
We have done things though, just in case, because sometimes people are like, that's all I've got. It's all people out of the country. A lot of times what we can do is if there's somebody in the US that's more like a friend that you want to have service trustee, what I've done a lot is I'll have the non-US person have access to information as though they were a trustee. So then they can do the job that you really want them to do, which is protecting the kids' interests. If your kids are minors and you're looking for whoever is taking over the funds to really kind of be policing the trustee to make sure they're doing the right thing. So you can pull them in other ways without giving them that trustee title. Again, all part of what we get discussed in the context of designing your full estate plan.
Yeah. Can we receive a copy of the presentation? The presentation was recorded, and I believe Lindsay will either post it or send it to people. But it was recorded today.
It was recorded, and if you're talking about the slides, we can send the slides. That's not a problem. Mm-hmm. And Peter asked if you put $500,000 home into a trust today and the client passes in 5 years with property worth $1 million, what is reported on the estate tax return? So you would report it. First of all, I don't want to answer this too generally, because sometimes people draft Medicaid trusts and take out certain provisions because they want the assets in the trust to also save on estate taxes. So this could be a different answer depending on the terms of the particular trust. But generally speaking, the Medicaid trusts pull the asset back into the gross taxable estate. So that means at the date of death, you would value all of the assets that someone owned, including what was in their Medicaid trust, and that's what would go on the estate tax return. And that's kind of intentional because we want that step up in basis, particularly on the real estate, so that if the kids or the family turns around and sell the property, they won't pay any capital gains tax. But it's definitely, again, part of what gets analyzed in the estate planning process, because you're kind of looking at, okay, what's going to be better for this family, estate taxes or income taxes, and you're kind of picking.
Yeah, it really depends on what your goals are, because it can be drafted to be includable or not includable. So it really just depends on the overall strategy.
That's all the questions.
And I think those are all the questions that we have. Keep in mind that we will have another presentation next Tuesday, the 23rd at 8:30 on the role of the trustee, where we'll specifically focus on what it's like to be a trustee and all of the things and responsibilities they have to do if they're acting as a trustee of a trust like this or of any trust in general. And then after that, June 12th, we will have a presentation on serving as a power of attorney. So if you are thinking about naming somebody to be your durable power of attorney, or if you've been named, this will kind of give you an insight on your job and what your responsibilities are as a power of attorney agent for somebody. And then our last presentation will be June 30th, and it's on avoiding and simplifying probate. So just the process of what you have to do to make sure that you do not have to go through the probate process. And then if you do, what all of that entails.
And for those of you that are on that are advisors, because I did see a couple of you that are advisors and even I guess clients that are on or potential clients. If you have ideas about other presentation topics that you want to hear about, we're always open to that, because we kind of picked these based on where we get the most questions and also where we see the most mistakes being made. So we've identified these as important topics, but I'm sure in your practices, you're getting common questions as well. So if you have any of those that you want to throw at us, we'll probably do, I don't know if we'll do another summer educational series, but maybe fall, like early fall, and do another set of presentations. So thank you everyone.
Yeah, definitely open to ideas. So if you have any, let us know. And then after the fact, if you come up with any questions that you think of later, sometimes I know when you go home and you digest things, you're like, oh, I should have asked that. My email's on the screen, so feel free to reach out and shoot me an email. I'm happy to answer any follow-up questions that kind of pop into mind later. And
we still do complimentary consultations, so definitely shoot Shawnee an email. She can get you on her calendar to do that probably pretty soon, within the next week or so.
Yep. All right. Thanks everybody for attending, and hopefully we'll see you guys at the other presentations this summer.
Thank you. Bye everyone.